Welcome everyone. Delighted you're able to join today's session, which is all about navigating the new employment laws coming into force on 6th of April 2024. I'm Rena Christou, Managing Director here at Halborns, and we're part of the brilliant Empowering People group who support with simplifying employee experiences and empowering people to drive business success. A quick bit of housekeeping before we get into the session and a little bit more about what you can see in front of you. The screen is customizable, so you can drag and move the speaker and slide views to position them how you prefer. You'll also find speaker bios listed in the panel next to these. We've also included some resources on the topics which you can download during the session, and we'll also send these out to you after the webinar. Lastly, you can see a contact us button so you can get in touch with us at any time. And if you'd like to ask a question, there's a Q&A comment box at the bottom of your screen. We'll try our best and answer as many questions at the end of the session. But if we don't get to them, which we may not get to all of them, we'll follow up with answers after the session. So I'm also joined today by Halborns Head of Legal, so Stefan Mars, to share his extensive employment law experience and expertise on what the changes mean for businesses, as well as Oliver Downs, Account Director at AdviserPlus, to show his insight from working closely with his clients and customers and how they're tackling those changes in practice. AdviserPlus are also part of the Empowering People group. Stefan, Oliver, over to you to say hi.
Hi there.
Hi, everyone.
So new employment laws have certainly been coming thick and fast this year, and we've got 4 coming into force just on the 6th of April alone. So they're going to be the main focus of today's session, but we'll also top and tail with the headlines of changes that have already come into force and what else we know is coming down the track a little bit later on this year. So between the 3 of us, we're going to give you a clear and concise summary of the need-to-know detail and the practical impact of the changes so that you're all set for when the laws kick in. There's lots for us to get through. Let's get cracking. Stefan, if I kick off with you first. So before we get into the main bulk of this session, do you want to give us a quick headline summary of the handful of changes that have already come into force?
Sure, yeah, so there are 3 things that we're just going to mention before we get into the 6th of April changes. So they are changes to spent criminal convictions, some tweaks to the definition of disability for employment law purposes, and some changes to holiday pay. So spent criminal convictions, so this one came in 28th of October 2023, and the headline is convictions become spent quicker than they used to, basically. And some convictions that used to never become spent now become spent. So for example, prison sentences of over 4 years, which previously never became spent, now become spent over 7 years. And the reason this matters is you may have somebody applying to you for a job where they're legitimately going to be saying, I've got no criminal convictions. And in fact, if they had a prison sentence more than 4 years, but it was more than 7 years ago, they don't need to tell you about it. So basically, the takeaway for that one is do some more in-depth background checks for senior roles and potentially roles where criminal convictions might be a particular issue for your business. Then we've got some tweaks around the definition of disability for employment law purposes. So this one kicked in on the 1st of January. So obviously disability discrimination is an employment law concept, but curiously the definition of disability only ever focused on day-to-day activities. So non-work activities, things like washing, dressing, carrying bags of shopping, walking up the stairs, concentration, that kind of thing. But it didn't focus on work tasks. So they've tweaked the definition of disability for deciding who is disabled for the purposes of employment law, and now include work tasks as well. So it's both day-to-day activities and work tasks as from the 1st of January 2024. And the reason this matters, or may matter, is that it's going to make it slightly easier for those who have specialist skills as part of their work to show that they're disabled for the purposes of employment law. So, I don't know, a fertility doctor, for example, that needed fine motor skills to carry out their job, that wouldn't previously have been part of the day-to-day activities for the purposes of the definition of disability. As from the 1st of January 2024, that's changing. So it's now refocused that definition both on day-to-day activities and work tasks. Then we got some changes to holiday pay. So this has been a kind of hot potato in the world of employment law for quite a while. So 2 main changes there. One is around holiday pay for irregular hours workers. So most obviously 0 hours workers. And just very briefly on that, until recently, a lot of employers were calculating holiday pay for those irregular hours workers based on a rolled up holiday pay system, basically. So you'd accrue holiday whilst you worked at a rate of 12.07%. Then there was a case in the Supreme Court called Harper Trust in Brazil, which put a coach and horses through that and basically said you couldn't do that anymore because it didn't comply with the working time regulations. The good news for employers is you can go back to that system if you want to. So as from holiday year starting from the 1st of April this year, you can go back to the 12.07% holiday pay accrual system if you want to. If you change the holiday pay system as a result of that Supreme Court decision, then you can carry on doing that going forward. But if you want to, you can go back to that previous position in relation to accruing holiday pay based on 12.07%. And then finally, on the holiday pay front, we've got variable elements of pay. So things like commission and overtime. As from the 1st of January 2024, you basically need to calculate holiday pay to include those variable elements of pay. A lot of employers have changed because of a series of changed the holiday pay systems because of a series of European court decisions. And this change in our law is basically incorporating that European law principle into the domestic law as from the 1st of January this year. So basically, what you're supposed to do is calculate holiday pay based on the previous 52 weeks average, and including those elements of variable pay, like, as I say, commission and overtime, as long as it's regular. So in a snapshot, that's the three things that are already in, and hopefully that will clarify, and we can move on to the 6th of April stuff now.
Thanks, Stefan. That's really useful. Right then, on to the first of the 4 changes kicking in on 6th of April. And we've got changes to statutory paternity leave. I'll kick off with those first. And if I just do a quick whistle-stop tour of what they are. You might be thinking changes to paternity leave. Is there something radical coming? Sadly not. So the changes aren't as exciting as we perhaps like them to be, but there are changes nevertheless. And this applies to babies being born where the expected week of childbirth is 6th of April onwards. So the current position is that you can take 2 weeks paternity leave, but you need to decide whether you want to take the 2 weeks paternity leave in one go or just 1 week's leave. So you can't split them, and you'd need to take them within the first 56 days of the baby being born. The changes are that actually you can now decide to split the 2 weeks leave, so take 1 week's leave early on and another week's leave later, if you wanted to. And you've also got the flexibility to take up to 2 weeks leave within the first 52 weeks after birth, so not quite as restrictive. From an employer perspective, it's just worth noting that the employee needs to give you 28 days notice of the intention to take the paternity leave.
And Rena, do you think that will lead to a change how paternity leave's taken, or do you think it will be very much as it is now?
So, and the uptake of paternity leave, actually, when you look at the statistics, is not as high as you'd expect it to be. So a lot of partners certainly don't take the full 2 weeks leave entitlement. So I think that we might see, as a result of the flexibility around when you take the leave, a bit more uptake, because actually, especially for organisations that don't offer enhanced paternity leave, taking 2 weeks of statutory leave can, at a time where your partner may also be on statutory leave, can be quite financially restrictive. So I think having the flexibility to take the leave at times that are genuinely suited to you and your family, and not having to take them in one go and having the flexibility to take that second week at a later date, I'd anticipate that we will see some more uptake on paternity leave, which has got to be a positive thing. So the next changes, well, just before we move forward, actually, I would just say in terms of the paternity leave policy, so there are some updates that need to be pulled together. And I just wanted to give you kind of a bit of a taste of our tone of voice as to how we would draft policies. So we've had a look at other policies that are out there, and also toyed around with ChatGPT, I have to say. And actually, again, to think that these are family-friendly leave policies and that we want to encourage individuals to take it and to understand that, the culture that you want to create as an organisation, you can just see a slight difference there. Well, more than slight difference in terms of how we present the same information and in terms of our template policies. So if you'd like any support with that, then please shout out. So moving on to the next change then, we've got a change to the right to 1 week's unpaid carers leave. Stefan, do you want to break that one down for us?
Sure. So this is a brand new right, obviously kicking in on the 6th of April 2024 for up to a week's unpaid leave per year for those with caring responsibilities. So this is aimed at carers. So that's someone providing care for someone with a health condition lasting at least 3 months. Someone who's disabled or someone who needs care because of old age, and it includes those caring for a spouse, civil partner, child, parent, or person who lives in the same house. So yeah, the purpose of the leave is either to provide care, to attend medical appointments with the dependent, or to arrange care for them. And the carer will be able to take leave as full days, half days, or any period in between up to a full week per year. There's also a right for you as the employer to delay leave by up to a month if taking the leave when the carer wants to take it is going to cause your business undue disruption. So there's a procedure whereby you tell them that, sorry, you can't take the leave when you'd like to because it's going to cause our business undue disruption, but we can let you take the leave within a period of up to a month. There's a right, as in common with other statutory rights, for you to be protected against detriment or dismissal as a result of taking this time off, or obviously if you dismiss somebody for taking carer's leave, then that's likely to be automatically unfair. And the notice provisions are that you basically, as the carer, have to give twice as much notice as the period of leave you want to take. So if you want to take 4 weeks leave, you have to give 2 weeks notice, subject to a minimum of 3 days notice. So for a half day or a single day's carer's leave, you need to give 3 days notice, as I mentioned. And as I mentioned also, there is this provision to delay the leave by up to a month from the employer's point of view if it's going to cause your business undue disruption. In terms of practical takeaways, you'll obviously want to create a system to track the number of days taken up to the full week year. You'll need to introduce, or would suggest that you introduce a self-certification form for employees to complete. You'll need to train your managers in relation to this new right. And you'll obviously want to introduce a carer's leave policy. So just another flavour of our Empowering People Group policies here. We've obviously spent a lot of time drafting these policies. They're not by any means off the shelf. They're very engaging, clear and concise. So if we can say it in a paragraph, we say it in a paragraph. We always emphasise the positive wherever possible, but obviously still pretty. And yeah, we include flowcharts, obviously, and wherever possible, just to give you a clear visual representation of the policy. So that's carer's leave.
Thanks, Stefan. That's really clear and helpful. Organisations often see misconduct with similar types of leave. Is there a potential for this being open to abuse, and is there anything that employers can do to prevent that?
There are definitely some concerns from the clients I'm speaking to about potential abuse, primarily because there's no single document, or there is no document that says I'm a carer. So that's the reason for suggesting that you have a self-certification form. So you get the carer to fill in the form to confirm that they're eligible for the right. It is obviously unpaid. Clearly, you can choose to pay for the leave if you want to, but there's no requirement to. So that's likely to reduce take-up potentially. But obviously, if you do discover that somebody has abused the system and claimed to be eligible for this leave when they're not, you can clearly deal with that under your disciplinary procedure as an act of misconduct.
Great, thank you.
Yeah, absolutely. Like you say, Stefan, the fact that it's unpaid, and if we look at other types of unpaid leave, actually in practice, employees and managers and businesses alike try to accommodate the need for flexibility with, other forms of support that are available. So you often get individuals asking to take holiday instead, and that's certainly the intention of carers leave, is to give them flexibility so they're not having to dip into other types of leave. But I think in practice, because it's unpaid, that's certainly something that we'll continue to see, and that will mask the need for carers leave perhaps, or making up the hours at other times. So watch this space for sure. So thank you both. Right then, up next we've got changes to flexible working. So if I flick through to flexible working and take you through those briefly. So obviously the right to make a flexible working request already exists, but there are changes coming to that process. The key changes to note are that actually it's going to become a day one right. So there was a lot of toing and froing whether that would happen, but the need to have 26 weeks service from 6th of April will be dropped, and that individuals will have the right to put a flexible working request in on day one of employment, which is, as I'm sure you'll appreciate, has caused some concern from employers and may result in some changes, which we'll come on to. But we do know a number of organisations that have already got that in place, so we can talk through that in a moment. The other key change to note is that you have the right to put in a second request, so you get 2 requests a year rather than 1. And the time in which to deal with the request is dropping from 3 months to 2, so a slightly smaller window for employers to progress requests. So something worth bearing in mind, especially if you're offering a trial period, is to make sure that you agree with the individual, if you are offering a trial period, to extend that 2-month period to ensure that you can complete the trial within your kind of revised timeframes. The other change to note, although I don't think it's particularly exciting, because I think it was happening for most employers anyway, is that there is a requirement to consult with the employee before rejecting a request. Naturally, that would be a step in the process when you're discussing the request anyway, we'd hope. So hopefully not any additional work there. One of the points worth mentioning is that when an employee makes the request, you can no longer ask them to consider the impact that their request will have as part of their initial request. But as I say, if you're consulting with them anyway, then it's definitely worth discussing it as part of that consultation process. So again, there are some changes here that are needed to policies and template documents to reflect those changes, to reflect the changes in timeframes and when the request can be made, and also the template documents supporting it. So as I say, to remove things like the need for an employee to outline what the impact of their request will have from the get-go. In terms of making those changes, the only thing I'd mention is ensuring that managers are trained and empowered to understand how to deal with requests, because again, if they're not aware of those changes, for example, and they do receive a second request, it might be that they think that they can automatically reject it when that's not the case, and an individual will have the right to make the request within that 12-month period. So Oliver, Stefan, we all obviously support clients across a range of different sizes and sectors. It'd be great to hear what you both think in terms of the impact that these changes might have. So do we think there's going to be a marked increase, not much change? What do you think?
Right, shall I kick off? So, I mean, I think it's certainly likely to increase the appetite amongst employees for flexible working, which obviously has been on the increase since COVID and lockdown anyway. The government is running a campaign, you've probably seen in the media, to try and highlight these changes to flexible working, because frankly, prior to that campaign, the knowledge about the fact that they were coming, wasn't high. Certainly there was a survey done by ECAS, I think, that said that only 30% of people knew that the changes are on the way. So at the moment, there's work to be done by the government, I guess, in terms of publicising these changes. Obviously, the day one thing is a bit concerning to a lot of employers, whether in fact you're going to get many employees who turn up on day one and actually stick in the flexible working request. We'll have to see. Hopefully that's unlikely. But I think, as you mentioned, Rena, certainly some businesses are actually trying to put a positive spin on this and trying to embrace the change and potentially seeing it as an opportunity to widen their target audience in terms of the demographic. That was certainly the intention behind these changes, to try and drive participation in the workforce by groups that may not be fully integrated, like the disabled, those with caring responsibilities, and in some sectors women. So yeah, I mean, I think there are definitely going to be some changes. The significance of them we'll have to see, but it's certainly going to increase the appetite, I reckon, from employees for flexible working.
Yeah, totally agree, Stefan. So from the businesses that I've been speaking to, I think we're all expecting an increase in requests. So currently the process is fairly underutilized, with maybe one request every 200 employees on average per year. So there's definitely room for growth there. One of the barriers I think that is probably quite key is that the employee no longer needs to justify the solution for their new working pattern. So the burden's really with the employer to consider that. I think the considerations really around training and getting managers prepared. So as you can expect, with such a low volume coming in at the moment, lots of managers haven't managed a flexible working process. So having robust training available for all managers is going to be quite important. And then separately tracking compliance as well. 3 months has obviously now shrunk to 2 months to finalise a process. So it's going to be important that that's tracked through.
Absolutely. Thank you both. So last but not least, in terms of 6th of April changes, we've got changes to redundancy protections around pregnancy and other family related leave. Stefan, do you want to share what's changing there from the current position?
Absolutely, yeah. So these are some changes aimed at providing additional protection for pregnant women and those taking maternity, shared parental or adoption leave. So this applies where you are informed of the pregnancy on or after the 6th of April 2024, or maternity, adoption or shared parental leave ends after the 6th of April 2024. So the headline is that the protection currently applied to women on maternity leave is not changing. So there isn't actually, that protection isn't actually very significant. So it doesn't stop you from, as an employer, making a woman who's on maternity leave redundant. It doesn't give the woman any advantage in the redundancy selection process itself. The only thing it does is give an employee on maternity leave preference for any suitable alternative roles. So if you've got 2 employees who are at risk, one of them's on maternity leave and you've got one suitable alternative role, the woman who's on maternity leave gets the suitable alternative role in preference to the employee who's not on maternity leave. So basically what's happening is that protection that currently applies only during maternity leave is being expanded in terms of the window. So it's going to apply from the date the employee notifies you that they're pregnant until 18 months after they return from that leave. So same protection, just a much longer period, essentially. So it also will apply to those on shared parental leave and adoption leave for the first time. And obviously it applies to those employees returning from shared parental leave and adoption leave as well. So given that these rights apply to some men, taking shared parental leave and adoption leave is going to apply to men for the first time. And in terms of practical takeaways, obviously you'll want to train those responsible for implementing redundancy processes on the new rules and ensure that you update any applicable policies.
Brilliant. Thanks, Stefan. So I think that's everything we've got changing on 6th of April. Oliver, Stefan, thank you so much for breaking it all down so clearly and sharing your practical insight. We have had a few questions come through as we've been chatting through these 4 changes. Before we close off the session, let's tackle a few of those together. So let's have a look. First one. This one is in relation to carers leave. So the question is whether an employer can ask for evidence if they offer enhanced terms beyond the 1 week unpaid leave. Stefan, shall I throw that one in your direction?
By all means. So yeah, the legislation certainly says that in terms of the basic statutory rights, so unpaid carers leave, you can't ask for evidence, largely because there isn't evidence, as we discussed, there isn't any document that proves that you qualify for carers leave. You can ask them to sign a self-certification form, absolutely. If you're going over and above that, then potentially yes, you could ask for additional evidence. You could make that condition of the payment over and above the unpaid statutory carers leave, but not in respect of just the statutory rights. So yeah, that's the position there.
Thank you, Stefan. Also, just to add, actually, in terms of enhancing the entitlement in respect of carers leave, one thing that I've been seeing certainly is rather than enhancing the pay, Some organisations are offering 2 weeks of unpaid carers leave. And the reason for that is that they're saying, well, actually, we think that an individual could really easily eat into the first week's leave, and we want to support them. So again, that they're not having to dip into holiday entitlement or other types of support that they might need. So just something else to think about as well. Second question is, so next question is about the redundancy changes. So you've just talked us through, Stefan, kind of the preference around suitable alternative employment. And the question is, what happens if you have two individuals that are both protected as they've both taken family-friendly leave? So who gets priority in that instance?
That's a really good question. The legislation does not say anything about that, unfortunately. So essentially, our view is you're going to have to come up with a tiebreaker. So some sort of fair criteria to choose between two employees who, on the face of it, have priority for a single suitable alternative role. So something around an additional scoring criteria that's obviously non-discriminatory, or potentially having some other extra stage of the process, like an interview, for example, which you then use to decide between the two employees that have priority. So you've got to come up with some fair criteria, clearly. And our suggestion would be, either an additional scoring criteria that you would score both employees against, or an extra stage of the process, like an interview.
Yeah. Oliver, do you think that that we're likely to see an increase in grievances? So Stefan's mentioned that for the first time, this will apply to partners as well, whereas ordinarily that wouldn't be the case. So do you think that we might see individuals feeling aggrieved if they've taken less, they've got somebody else that's taken less family-friendly leave that's also being given the same preferential treatment?
Yes, potentially. It's probably not a huge number of grievances that we see related to those specific circumstances, but that could grow. There's no reason that employers shouldn't consider that when they're thinking about these selection processes and whatnot.
Absolutely. Well, brilliant. Thank you both. We've also got a handful of further changes to come around. So sexual harassment, predictable working, and neonatal care leave. So they're all coming down the tracks. But don't worry, we'll be running some extra sessions nearer the time to talk about those in more detail. For now, though, Stefan, do you want to give a quick headline as to what they might look like?
Sure. Yeah. So 3 further changes coming down the track: September, October, and April next year. So the first one is a new right to request predictable working pattern. So this has been on the cards for some time. The government have been talking about it for ages. So the kind of background is, obviously, the gig economy is under scrutiny. Something like 1 million people are working under 0 hours contracts. And if you're working on a 0 hours contract, for example, it's very difficult to get a mortgage. So the idea is, if you're working regular hours under a 0 hours contract, then you can make a request modelled on the flexible working regulations procedure for a permanent contract of, say, 30 hours a week. But interestingly, it's also going to apply to those on fixed term contracts of less than a year, and for the first time for agency workers. So an agency worker can actually ask the hirer for a direct contract of employment under these new rights coming in September 2024. Then we've got a really significant change in October. So new duty on all employers to take reasonable steps to prevent sexual harassment at work. New duty on top of the existing, obviously, sexual harassment has been unlawful for some time, but just ramping up the duty in terms of employers and what you need to do as an employer to show that you've taken reasonable steps, as I say, to prevent sexual harassment. So things like, obviously we'll come on to some more detail when we go through it on the session nearer the time. But yeah, so things like ensuring that you live by your policies, and not just having the policy, demonstrating that you live by it in terms of taking disciplinary action if somebody does commit an act of sexual misconduct, sexual harassment. And probably most crucially, training. So ensuring that you've got in-depth and regular training for all employees on what is sexual harassment and what the consequences are if you commit it at work. So yeah, really big, really significant change in October 2024 around this news issue on sexual harassment at work. And then further down the track, so April next year, new right to neonatal care leave. So again, something that's been trailed for ages. It's a new right to additional leave and pay in some circumstances for those who have babies who are born prematurely or are poorly in the very early stages of life. So if they're in hospital for at least a week during the first 28 days of their life, both parents are eligible for additional neonatal care leave on top of current rights. So it's added on to the current maternity and paternity leave, up to 12 weeks leave, mirroring the period of time the baby spends in hospital. The leave as day one rights, the pay kicks in after 26 weeks service. So obviously designed to support new parents to spend more time with their baby where they're born, as I say, prematurely or poorly in the first 28 days of life.
Thanks, Stefan. We'll also be emailing you with details of packages of support. So we've mentioned quite a few policies and documents here. So don't worry, we've got you covered, and we can drop you some more details on the packages. If for whatever reason you don't receive the email, then please reach out and let us know, and we'd be delighted to take you through those. And that brings us to a close. So we've had what seems to be years without much employment law change, and now it's all coming at once. So we hope you found it a valuable session today, and if we weren't able to cover off your questions, we'll follow up with you personally after the session. Oliver, Stefan, thank you again both for your insight and practical guidance today. As we've touched on, all these changes will require updates and amendments to your existing people documents and templates, as well as new documents to be introduced as well. The Empowering People Group is all about simple solutions to people challenges. So we're expertly placed to help with ensuring you're implementing all these changes in a compliant and consistent manner. If you'd like our help with anything we've covered, please get in touch using the contact form available on your screen, and we'd be delighted to chat through the solutions we have to get you to where you want to be. We've also included a handful of free resources for you to download, so a document checklist, so you can cross-check where the changes need to be made, as well as a comprehensive guidance note on all of the employment law changes this year. So well worth a look, and again, download from the resources section on the screen in front of you. So thank you again to everyone joining us today. We look forward to seeing you all on another Empowering People Group webinar in the future. Thanks.